to Sidebar, Bracewell's podcast devoted to government enforcement and investigations, corporate compliance, and white-collar criminal defense. I'm Phil Bezanson.
And I'm Matthew Nielsen.
And we're your hosts and are both partners at Bracewell LLP, where we represent companies, boards of directors, and individuals in all manners of litigation, investigations, and enforcement actions. Matthew, can you tell us a little bit about who we have today as our guest?
Phil, today we have an outstanding guest to talk about the fascinating world of congressional investigations. But we're going to need to be on our best behavior, which admittedly is a very low bar, because our guest today happens to be our boss, Steve Braga, who chairs Bracewell's Government Enforcement and Investigations Practice Group out of the DC office. Among his many accomplishments, Steve has secured the release of not one, but two men who spent decades in prison for wrongful murder convictions. He's also been a law professor at the prestigious University of Virginia Law School. And relevant to our show today, he spent more than 35 years defending individuals and corporate clients in congressional investigations, including in some of the most high-profile matters like the Jack Abramoff lobbying scandal. And Phil, because you're based in Seattle, I understand he's also best friends with Eddie Vedder.
Yeah, that does make Steve an honorary member of the Seattle office.
Steve, welcome to Sidebar.
Thank you, guys. Good to talk to you today.
So, Steve, let's just start off talking about the reality of congressional investigations. I think everyone's familiar with a part of congressional investigations, and that's, I guess, the hearings that we all see, whether it's the impeachment stuff we saw under Donald Trump, or the various types of hearings that were going on into all sorts of allegations of wrongdoing. But I get the sense that's not really the world of congressional investigations. So can you just at a high level tell us what really happens here?
Yeah, that's right, Matthew. So the hearings that you see on TV are sort of the end piece of the investigatory process, like a trial would be the end piece of a charge in criminal court in the white collar work that we usually do. Although I'm wondering why you guys aren't doing it today and are bothering me with this podcast instead. The starts out with fact gathering by the legislative staff usually, and it usually starts out with a voluntary request. There are very little rules that govern this stuff. There are rules about deposition subpoenas and subpoena power in general, but more likely it's all informal, and it can happen that a legislator or a staff committee member can send just a letter to one of our clients and say, we'd like the following information, or we'd like you to show up for an interview. And that's really where the representation gets started, is how do we respond to that voluntary request? Do we want to comply with it and show respect for Congress and not incur the wrath of Congress if we don't respond to it? Or do we want to take a different position? And one might think that, government officials in particular would respond to voluntary requests from Congress for testimony, but just a couple of weeks ago, Janet Yellen refused to testify before a House committee that wanted to have her testimony on the Paycheck Protection Program. She had good reason for not wanting to testify, but once you make that decision not to comply with a voluntary request, then you sort of get in an adversarial position. And the chair of that committee, even though a Democrat, Nydia Velázquez, called out Janet Yellen regularly and repeatedly for failing to come testify. So it all starts with Congress's effort to get information voluntarily from a company or an individual. And that's a little bit unusual, right? In litigation cases, you don't get a letter saying, please send us the information we want. Usually it's a subpoena or a document request. Here, because it's voluntary, it gives more play for the lawyers to interact with the committee staff and try to narrow the grounds that they want the information to relate to, because we don't have to give it to them. If you want to get something from us, work with us to make it manageable, in other words.
Well, depending on sort of the politics of the matter, particularly, as things have evolved over the last number of, recent years at least, when you get one of these letters, is there any play or opportunity to say, okay, well, whatever party's in charge wants this stuff, let's go to the party that's not in charge and see if they can push back and fight this fight for us? Like, is that part of the process?
Not only a part of the process, Phil, but it's an essential part of the process. And so if these representations are done right, there's lots of ways that they can be done wrong, of course, like any judicial proceeding we are familiar with. If they're done right, the company, the client, individual, or company works with the staff on both sides to try to narrow first with the people who want the information. And then if that's not successful, to go to your friends on the other side, assuming they're, in opposition to the majority party, and say, hey, can you try to help us narrow? Can you give us guidance? Or to set that other side up to make requests of their own that then put the things in a fairer posture. And this is done with the utmost skill by our PRG group at Bracewell. So Scott Siegel and Dee Martin and the people who work in PRG monitor information requests on the Hill from all sorts of legislative committees and legislators, trying to know, hey, they're going to come and ask our client for this, or they've already drafted a letter for this, or we've already gotten a letter for that. And how do we get in that door? Again, like almost all of the representations we do, the earliest you can get in to have those discussions, the better, because then views aren't set in stone. Just like with the grand jury subpoena, you'd love to get it the first day and start talking to the prosecutor rather than getting it from the client the day before the response is due.
So, Steve, are these almost always just part of the partisan politics? Or do they actually involve, I don't want to say real issues, but kind of significant down the middle of the road potential problems?
So if you look back historically, when I was a young lawyer and you two either were in diapers or grade school, you have these grand hearings, right? You had the Watergate hearings and Senator Ervin and the Joint Committee, and then you had the Iran-Contra hearings with Oliver North. That is the paradigmatic, congressional hearing done right. It starts off with requests for information. It works through interviews and depositions. It leads up to a hearing that looks sort of like a trial, although it's not really a trial, because another unique feature of congressional investigations is that the party that wants the information from you also happens to be the party who's going to judge whether you've complied with it. There's no neutral arbiter, in other words. But so back in the old days, those grand hearings were really, really, truly fact-finding expeditions as part of Congress's oversight function to keep the public informed about the way the government was working, and if it wasn't working, to change things. I'm afraid to say that in the modern day, especially with the advent of social media and probably fueled by how bitterly partisan our politics have become, more and more of these hearings tend to become a legislator's search for a viral soundbite, to the point where, the sage Scott Siegel at PRG in our office says to clients who ask, quote, no one should want to testify at a public hearing in Congress unless they have built a better mousetrap. In other words, there's no upside to be gained by testifying before a hearing in Congress these days in most investigations, because it's really not about finding the facts. It's really not about directing a result. Most of these hearings tend to be about finding a soundbite for the legislator or the committee in question.
So then why do it at all? I mean, is there a brinksmanship component of this where you say, okay, you sent a voluntary letter? No. So
the why do it at all is because the response to the voluntary letter isn't the end of the inquiry, Phil. So Congress has the power to investigate anything relating to their power to enact and appropriate. So it's a very broad legislative purpose. And they take the view of that legislative purpose that it's unbounded by any privileges as well. They don't recognize attorney-client or other privileges, they say. So if you don't comply with the voluntary request, they have the power under their rules to issue compulsory process, subpoenas for documents, subpoenas associated with deposition notices, and of course, subpoenas to bring people in to testify at a hearing if the hearing is eventually held. So the question at the first juncture of whether to comply with the voluntary request or not is, am I better off trying to negotiate something off the voluntary requests? Will that be better for my client in the long run? Or is the committee or the legislator in question so adverse to my client that complying with the voluntary request is out of the question, and I'm just going to not do it and make them issue a subpoena, and then maybe I can take the subpoena to court and fight its enforcement on the ground that it's not truly based in a legitimate legislative purpose. One of the common things we saw in the Trump administration was the Trump administration fighting congressional subpoenas on the grounds that the legislative purpose behind them was not, quote unquote, legitimate, because it was, in fact, truly political, just trying to get the president. And they had some success in some courts at delaying and alleviating their enforcement obligations under subpoenas.
Well, one of the things that we encounter fairly frequently in the sort of traditional criminal environment is if an individual client is asked to speak with the government, there's an assessment of, well, do we want to invoke our rights under the Fifth Amendment to not say anything? Where does that fit in this sort of analysis? Can someone say, no, I have rights. I'm not going to say anything. Go get your subpoena. I don't care if it's a legitimate purpose or not, or if it's purely political. I'm not answering any questions.
So although Congress says it doesn't respect privileges, what it really says is our legislative purpose behind an investigation is of primacy versus individual and corporate rights in responding. In other words, we as the legislature are a coordinate branch of government. We're entitled to do what we need to do to fulfill our function regardless of privilege. It is true, of course, that the individual's Fifth Amendment rights are routinely claimed in Congress. When I represented Mike Scanlon in the Jack Abramoff investigation, Mike, after Jack, was called to testify before the Senate Indian Affairs Committee, and both of them took the Fifth in response to every question because there was no upside to them answering any questions. It was a purely political inquiry, and they had full fear of self-incrimination, as subsequently, was revealed when both of them pled guilty. So the Fifth Amendment is there. Congress says they don't have to recognize it, but they have never tested it in court, Phil. So Congress is never going to court and say, we're not bound by privilege. They just say, as part of their negotiation with clients and lawyers dealing with them, that, we don't have to be bound by privilege. And so we'd like this portion of your attorney-client, or we'd like that portion of your Fifth Amendment rights, somehow work with us on this. Never been tested in court, though. 2 years ago in a Supreme Court case called Trump versus Mazars, LLP, President Trump's accounting firm, the Supreme Court did say, and I think it was Justice Kavanaugh who wrote this, I'm not sure, something along the lines of people subject to congressional subpoenas have historically been recognized as holding privileges, such as the attorney-client privilege, the most important privilege in that case in particular. So the court does seem to recognize that individuals receiving congressional compulsory process still have privilege rights. Congress seems to recognize that they don't, and it's never really been battled out. And that's probably because Congress and the recipients tend to work it out, or it's so clear that Congress would lose if they went to court. If Congress went to court and said, Mike Scanlon, Jack Abramoff, I understand you've invoked the Fifth Amendment, but, we want you to testify anyways, there's no way they would win that case in the federal district court for the District of Columbia. That subpoena would not be enforced. The Fifth Amendment rights would predominate.
Steve, it sounds like one of the goals here is obviously not to create collateral consequences for the client, whether it be, kind of criminal investigation resulting from the congressional investigation or some other, or perhaps significant, PR hit in the case of a corporate client. Assume you want to avoid the show of a congressional hearing that may actually be put on TV. But what are the other, though, landmines that you're looking out for when you're dealing with one of these investigations?
So the primary landmine, Matthew, these days in the modern type of, hearing looking for a viral moment or a soundbite for a legislator or a staffer is to avoid that PR hit. And it can be significant when you go back and look at some of the car manufacturers' stock prices, drug company stock prices, financial company stock prices after particularly bitter and adversarial hearings. There's a million, sometimes $1 billion drop in value. So that it's not just a PR hit that hurts because reputationally you might have been smeared by a congressional committee. It can really hurt in the real world. To try to avoid those landmines, this goes back again to my point earlier about trying to get involved and trying to work with the committee staff on either side at the beginning to try to manage this thing is, if you have good information, if your company or individual has done nothing wrong, you want to be forthcoming. You want to work with that committee staff. If you're in the middle, you want to sort of try to be in a delicate dance with them, give them some of what they want, but not give them anything that would make your individual or make your company's CEO a target for a public hearing. In other words, if you can get through Congress's preliminary fact-finding process through voluntary and or compulsory process with the result that your client does not appear to be one of the bad actors that Congress would want to put on a panel hearing and then grill, that's where you want to be. And so you try to negotiate that, try to manage that in terms of selectively providing or offering information if you can along the way. And of course, having your witnesses, whether they be, individuals or corporate representatives, fully prepared so that what they give in testimony, what they give in interviews before the hearing is the kind of thing that doesn't make for a spectacle, doesn't make for a public show. If you have a CEO of a bank come in and no matter what's the best thing to say politically, he says what he wants to say. And for lack of a better word, I'm going to use a legal term here, pisses off Senator Elizabeth Warren. That's going to result in
hypothetically,
that's going to result in a big public to-do. Like last week when she called the CEOs of Citibank, Wells Fargo, JP Morgan Chase, and B of A to testify about their conduct with regard to charging customers overdraft fees during the pandemic when the banks themselves had their overdraft fees obligations waived by the Federal Reserve. And, the banks tried to explain their side of the story. And Jamie Dimon, as usual, gave an eloquent explanation for JP Morgan Chase's side of the story. And Senator Warren shot back at him, quote, "That's $4 billion worth of baloney, Mr. Dimon," close quote. That's the soundbite she wanted. That's the viral moment. That's what made the news, not any of the particulars of the actual practices in question.
So one of the things that I guess it seems also really different about the congressional investigation is how time works and how timing things works. Because unlike, the more traditional white collar investigations where you have typically career prosecutors or career enforcement attorneys running the investigation who are going to be around, who have been around for a while, will be around for a while, show up for work every day and go through investigative materials every day. People in Congress do a lot of other things, and some of them aren't going to be in Congress forever. So is there a way to use scheduling and political winds changing and elections and, summer breaks and stuff to push things out, or are you held to a tighter calendar for things like this?
So there are no rules in any event with regard to timing in congressional investigations, like there are rules, once you get a grand jury subpoena or once you're involved in an actual court case. So again, it's a little bit of the adversary who wants the information being in charge of the timing, Phil, just like being in charge of the rules, ruling on the questions as if a prosecutor were ruling against you in a court of law. But you can work with these things. And the most prominent thing that factors into this is the calendar, either in the House or the calendar in the Senate, the calendar of the committee in question. And again, as you start to work with these things early on, work with the staff who wants the information, work with the people you have relationships with on the other side if necessary and always appropriate, try to figure out, okay, how can we play this out so that the timing will not be too rushed. You never want to be too rushed because, for example, these things take longer to prepare than most lawyers think. Most lawyers think if you're going up to testify before the Hill, there isn't a judge, there's no real consequences other than a PR hit. Let's just go up and say what we want to say and get out of the way. It actually takes more preparation for somebody to testify on the Hill than it does in a court of law. Because in a court of law, you and I and Matthew know that certain questions won't be asked, like when did you stop beating your wife? No one's going to ask that question in a court of law. And if they do, a judge is going to rule it as irrelevant and not make you answer it. In Congress, they're going to ask that question if they want to, and they're going to wait till you answer it. And there's nobody to tell them no, because it's not a Fifth Amendment question. It's just a harassment question. So the preparation for a witness to be able to sit there and not respond to a non-question, sometimes the legislators will go on and speak for 3 minutes, articulating the soundbite they want, and never put a question mark on the end of it. And so the witness has to be ready to just sit there, and if there's not a question, there's no answer to be given. It takes a lot of prep work. So you want to make sure these things don't rush too fast. You can't think of it as a sort of an absolute calendaring matter like your question seemed to imply. Can you in effect run out the clock on a legislator who's leaving office or wait till political winds change? Obviously would be a dicey proposition because you never know how they might change. They might change for the worse. But there are some ways that you can work with the staff and work with the people on your side in the opposition party to try to figure out what kind of schedule might we see, and then how do we make that try to work to our advantage.
Steve, it just occurred to me a question I just don't know the answer to, but does one of the chambers tend to ask or do more investigations? In other words, is it the House versus the Senate, and are there just huge differences between the way in which they conduct investigations?
So there are huge differences in the process, and this actually goes back to Phil's point about timing. The senators, of course, serve for 6 years, right? So, once they're in, they have a longer horizon than the House members who are up for re-election every 2 years, which means, the ones who were just elected are already running for re-election in the midterms. And so the House tends to, in my view, have more sort of scattershot investigations, more shorter timed investigations, more hearings in order to try to get those viral sound bites they want. The Senate still today, I think, tends to look at more involved, more lengthy, more truly fact-finding investigations. And for many, many years, the Senate Permanent Committee on Investigations, called the PSI, Permanent Subcommittee on Investigations, used to be run by Chairman Levin, has done really, really good work with sort of the traditional types of hearings. So in general, I would say you'd be better off, a client would be better off, and it'd be easier to work with an investigation arising out of the Senate than the House, which tend to be more unpredictable and have people with less of the career experience that Phil was describing a few moments ago.
Plus, they're just always, in the House running for Congress, right? I mean, it's every 2 years. And then, I've seen some of these where, the second they get elected, they're right back on the road trying to raise money and gear for the next election. So if they're going to use this investigation as a way to help their, political campaign, I guess they're just always having to rush through them.
Yeah, exactly right. Exactly right. So the other thing about congressional investigations that people have to worry about is sort of the end result. We talked about the public hearing as being the end event in the investigation, and that certainly is true in most cases, but not always. Congress can decide as a result of a hearing that, though there are more leads we now need to pursue that we learned in this hearing, and so the investigation can go on. More importantly, Congress can decide to make referrals to the Department of Justice for potential prosecution of any criminal incidents they found during the course of their hearings or their workup, their information gathering. And frequently, Congress can refer to the Department of Justice potential perjury prosecutions if they think they've been lied to, or potential obstruction of justice prosecutions if they think documents and information have been altered or not provided to them. So there are real-world consequences to testifying before Congress. Again, in addition to the PR risk, which can be substantial, it can lead to further investigation. It can lead to criminal prosecution. And that's really where the rubber hits the road in terms of the need to have it prepared and have it done right in order to protect the client's interest.
Well, and also imagine you don't get the post-investigation steps of Congress moment where you can say, we've been acquitted, we've been exonerated, we've done nothing wrong, and say that with any confidence, because I assume you walk out and you say that, well, you'll probably get another letter asking for voluntary cooperation the next day because they think you were being, kind of a smart aleck about it.
Oh, exactly right. That's the ultimate trump card they have, is that, it can be, this stuff can be initiated with a simple legislators or staff committee letter. And, the ruling advice is go to a public hearing if you have to. Try to avoid it at all costs. Try to submit written testimony, work with your representatives on the other side, work with your lobbyists, work with the committee to see if there's a way that you're not an essential witness for the hearing. But if you are an essential witness who's called before the hearing and it's going to be one of those politically active hearings that's going to try to result in a viral soundbite, be prepared to go in with the mindset that you can't win. There's no winning in these hearings. There's only survival. And if you can survive and come out, be quiet and go on your way, because if you in any way take on the committee after testifying, they will call you back. And then one of the things they want to ask you about is why you did that and who'd you talk to? And was that part of your government relations strategy? And what about this? And what about that? It becomes an endless rabbit hole that you can go down forever.
You just used the term, a vital witness or someone who's a necessary witness to a proceeding. If you are such a person, in the criminal context, you can say, okay, well, if I'm so important and you need me, I want immunity. Is there something similar in the congressional investigation space where you can say, I know, you can refer something over to DOJ if you think something's wrong. What protections can I get? I'll come in and I'll talk, but, I'm only talking with something coming back for me.
Yeah, so really good question. And the Oliver North Iran-Contra hearings that I mentioned earlier had a huge issue arise about immunity for witnesses and whether North himself would testify without immunity. He ultimately, Williams and Conley, obtained some immunity for him, and Brendan Sullivan let him testify. And that, in turn, mucked up the possibility of a criminal prosecution by DOJ later, because North was able to claim, I've got immunity. they were able to, the prosecutors said, we didn't give it to you. And North said, well, a coordinate branch of government did. And that's what led me to testify. And I wouldn't have testified without it. And ultimately, it became a great piece of the defense work of Oliver North seeking that immunity. Other witnesses have not been, have not fared so well. So in one of my early congressional investigations, we represented Michael Deaver, the former chief of staff for President Ronald Reagan. Deaver left the White House and started a PR consulting firm called Michael K. Deaver and Associates, and quickly became very, very rich by essentially, and this came out in the criminal case that we defended, essentially trading on his access to the White House by, selling his time to people who wanted him to make a phone call to try to push forward an initiative. He was advised, that this is a criminal investigation as well as a congressional investigation. Maybe you want to take your Fifth Amendment rights. He decided, again, this is all public information, he decided that to save his business and his very lucrative practice, he would testify and tell Congress the truth. He testified before Congress in response to a number of questions. He said, I don't recall the answer to that. One of the questions, there's 5 charges in the case, but one of the questions, for example, that he did not recall the answer to was, do you remember calling the White House on behalf of Trans World Airlines, an airline that no longer exists? But did you make a call to them as a lobbyist? And that was in his restricted space because he had recently left government and he'd worked on airline matters. He testified that he didn't recall making that telephone call. He was indicted for not recalling by an independent counsel, Whitney North Seymour. And at trial, the jury was presented with the following evidence. On that phone call alone, Mr. Deaver made the phone call. The phone call lasted less than 40 seconds. Mr. Deaver was paid $540,000 for making that phone call. And the jury believed that anybody who made $540,000 for a 40-second phone call would remember that, should not be in a position to say, I don't recall it. So even if you try to get a little cute with saving your reputation, saving your business versus protecting your criminal interests, and, I really don't recall. And you and Matthew know, we testify, we tell people all the time who are getting ready to testify, if you don't recall, say you don't recall. Don't make up a recollection. So here, when Mr. Deaver up and testified that he didn't recall, no one knows except Mr. Deaver, of course, whether he really recalled or not, and he's left the planet, so we can't ask him anymore. But, there was enough evidence for a jury to find that, hey, somebody made this much money for this 40-second call, would have recalled it, and that ended up being perjury, and he ended up being convicted of that. So there are real risks all around, very fraught with danger, congressional investigations.
So, Steve, turning to a different question, because I see my friend and co-host sitting in his palatial sub-basement, which has made a second showing on the podcast. He has a basement to his basement. He's showing off.
It's not a basement to the basement. It's a part of the basement that just doesn't have any window wells or sort of access to the world. I mean, I'm sitting in a windowless room underground. So it's kind of a bunker.
But didn't you go down from your basement? Like you were in your basement, and I thought you went downstairs to a sub basement.
No, it's not it's not sub basement. It's just a bunker in the basement, and it's sitting in the shadow of my Peloton.
Bragger. So how did you become
frequently used Peloton?
It's part of the Bracewell Peloton group. Steve, how did you become best friends with Eddie Vedder?
So I wouldn't say we're best friends, but we are very good friends. And in fact, Phil doesn't know this because I never told him the end of the story. But my one visit to the Seattle office came after attending a ABA convention, speaking in Vancouver on a different topic. And I decided to go down to the Seattle office and visit Phil and as part of my tour of seeing the offices of the firm after I joined. When I found out I was going to Seattle, and I think it was a Friday night, I'm not sure. I wrote to Eddie and said, I'm going to be in town. Are you in town? Are you guys on the road? If you're in town, can I come visit? And he wrote back right away and said, you're in luck. We're practicing in the warehouse. The band's together. We're working on our music. Why don't you come by? And so I wrote a note to Phil that said, Phil, what are you doing later today? After I leave your office about 4:00, what are you doing later today? And Phil said, I have to go to one of my kids' sports events. And I never put any pressure on him by saying, well, Little League or Eddie Vedder and Pearl Jam. But, I know from Phil's devotion to his kids that he would have picked the sporting event anyways. So I got to the warehouse. I hung out with the band for an hour, had a couple of Coronas with Eddie, which is his beer of choice. And he then said to me, hey, the Red Sox are in town. And he knew I'm from the Boston area. I thought he was going to say, do you want to go to the Red Sox game with me? But he then said, I can't go because I've got to go to my daughter's Little League baseball game. I've got 2 tickets here. Would you like them? And so I thought again, Phil was busy, Eddie's busy. So I went down to the ballpark by myself with these 2 tickets, which happened to be in the front row on the third baseline, and enjoyed the game, courtesy of Eddie Vedder. So, Phil, I owe you a couple there, but I became friends with Eddie through work on the West Memphis 3 criminal case, 3 Arkansas teenagers wrongfully convicted of murder. Wonderful documentaries about it called Paradise Lost on HBO and West of Memphis by Peter Jackson. Eddie and the band were huge supporters of the cause that these kids were innocent, and in fact did a show along the way where all of the profits from the show were donated to the expenses of DNA testing. Ultimately, some DNA testing and some other work and some legal work proved that the kids did not do it. They had to cop to an Alford plea because the prosecutor was intransigent to sort of get out of the situation they were in. But we've stayed friends ever since then. And every time he comes to tour, be it around Charlottesville or around D.C., Baltimore, or sometimes up in Boston, I get an invite to come visit. And it's really, really fun. He's a wonderful man. And if you see the movie West of Memphis, you will see me say in the movie, I think he's really one of the most generous people with his time I've ever seen. I mean, he could, have nothing to do with anybody, especially a bunch of lawyers, but because we helped the cause he was interested in, he's remained very devoted and helpful to us. And I would like to say something about Phil's sub bunker, if I could. So it's actually right on point for congressional investigations because some of these committee staff work in bunkers like 3 levels below the Capitol or the Senate office building or the House office building. And if you go to try to talk to them about these voluntary compliance measures and how do I leverage this, how do I offer that, how do I get through this process, often you need a map to find them, and their situation, their rooms look a little bit like Phil's without the basketball equipment or the Peloton.
So you're saying that I'm, uniquely positioned to be a kind of training ground for anyone who wants to practice going to meet with congressional staffers. They should just come over and, they can find the way to my underground bunker. They'll be at least part of the way there.
I'm saying that, and I'm also saying you yourself would be a perfect candidate for us to send into one of those meetings because you wouldn't be claustrophobic.
That's true. I would absolutely feel comfortable.
Hey, Phil, what was the kids' game that you end up missing hanging out with Eddie Vedder in front row seats to a Mariners Red Sox game?
Well, I don't know off the top of my head, but I can probably go back in my calendar and figure out when Steve visited. And depending on the season, I think it would either have been a soccer game or if it was baseball season, it was probably a baseball game. Although I guess if it was a Mariners Red Sox game in the fall, it could have been a soccer game.
Yeah, I think it was in March, and end of March, maybe a couple of springs ago. But in any event,
then
Eddie is still sad that he missed you.
I'm sure he is. But I'm actually here in Seattle. So if he wants to get together, you should just send him my contact information.
Well, I would, but he's claustrophobic. He hates bunkers.
Right. You imagine Phil and Eddie Vedder hanging out in the bunker.
Could be a whole new podcast, Matthew.
It's a very comfortable bunker. I got a TV. I've got Pop-A-Shot. I've got my bike. It's not that bad. I've got my recording studio.
That's right. I keep trying to get Phil to do a show while doing a Peloton class, but
we could sell subscriptions. That would be a firm might like that. Instead of billable hours, we'll sell subscriptions to Phil on the Peloton.
I think we get a lot of refund requests.
You're not going to make any money with that. You're not going to make any money with that. I think we've probably reached our break point with this high quality project planning. So thank you, Steve, for joining us today. This has been great and really helpful to understand this otherwise sort of murky and poorly depicted on TV world of congressional investigations. So thank you for joining us on Sidebar. For anyone listening and everyone listening, you can find Sidebar at our firm's webpage, www.bracewell.com, and anywhere else where you get your podcasts. Thanks.
Thank you. Take care.
Thanks, Steve.